Hello, ladies and gentlemen. This is CASCAIDr's Principles podcast series, and it's session 2 on the basic need to follow the guidance, unless there's a very good reason not to. Today's session is going to feel like it's ripping into local authorities and NHS staff for unawareness of the need to follow the guidance. But if I'm honest about it, having spoken to people in social work for the last 20 years and knowing that the education that you go through before you get your social work qualification doesn't spend much time on which bits of law matter or which bits are even law, I'm not so very surprised that there is such a vast unawareness of it. So we're going to be looking at the Care and Support Guidance and the Mental Health Act Code in particular, and I've got some other juicy examples from other guidance instances or codes. The case law that we're going to look at today, because I'm always going to do this from the case law perspective, is a juicy case involving Islington LBC and the North Central London CCG before it became the ICB. And so I'm hoping that that will be great for you. So what is the legal status of the Care Act guidance? There's the link to it. I'm wanting to call it the Bible, but then I'm thinking that that's not woke, religiously speaking. I'm wanting to call it really the roadmap for how your functions should be exercised. Current social care guidance is, in legal terms, virtually mandatory for councils to follow. But the trouble is that there's no culture currently in place, in practice, of the staff reading it line by line or discussing it in huddles or quality assurance panels. And so practice is getting further and further away from the guidance. And that's partly, I think, because people don't understand that it is legally virtually mandatory. By some strange omission, the current guidance doesn't say what the status of the guidance is or why we can be so clear about it. So I'm going to do that instead so that there's no excuse not to know. There is a duty to act under the guidance, and it's mentioned in the Care Act itself in section 78. And that means that we generally call it statutory guidance, as opposed to policy guidance or practice guidance. Those types of guidance may just come from a government department, even in relation to a topic that there's no statutory underpinning for. Much of the COVID guidance to care homes, for instance, was practice guidance, but the DHSC has absolutely no control and no statutory route to giving guidance to care homes. Why do I say that the CSG is virtually mandatory? Well, it's because nothing called guidance, not even the stuff that is bolstered by a statutory reference, is absolutely binding. And obviously that must be the case if you think about it for a second. It would be called law rather than guidance if it was absolutely binding. I'm not sure that even if it was law, it would be any more likely to be followed these days. And that's one of the problems I spoke of last week, a general evaporation of regard for the rule of law. What it means for something to be legally, virtually mandatory, but not binding, is this, in simple terms. If a council's decision makers, whoever they may be, and that's either a manager or a panel or the director, if those people don't know about it, or they don't appear to follow it, or they don't explain why they're not going to follow it in a given case, then the council would be open to judicial review. If it were to lose the judicial review case and not fall on its sword and very hurriedly revert to looking at the guidance before the proceedings got very far, then the funding decision, whether it was a revision of a care plan or a termination of a care provider's contract, it would be void and it would have to be taken again properly second time around. So if or whenever you're in doubt, whether you're a member of staff or whether you are a member of the public, look at the guidance. It's up there and it's electronically searchable with Control+F. So some of you might be thinking, what gives any Secretary of State or government department the power to write the guidance in the first place? And I have to tell you, it's the law itself that does that. And it used to be normal for government departments always to say what act and thus what legal authority the guidance was being issued under. And that seems to have been a habit that has gone astray over the last few years. But let me give you a very solid reason why I know that this is absolutely the case. Many years ago, when the Department of Health started to get rid of its policy team and parcel social care policy up and hand it out to the great and good in the sector, including the public sector, the voluntary sector, and the private sector, there was a consortium of people called the Putting People First Consortium, who were used by government in an early form of co-production to write the very first guidance on personalising social work process. I have to admit that I had a little something to do with that process at the time. The Department of Health then adopted the work and said this about it, formally. This guidance is issued under Section 7.1 of the Local Authority Social Services Act. It replaces fair access to care services, guidance on eligibility criteria for adult social care, which was the previous guidance issued in 2003. They said practice guidance to support effective implementation of this guidance will be published separately by the Social Care Institute for Excellence. So you can see that the department adopted the co-produced efforts of the sector and turned it into statutory guidance. The same thing happened with the writing of the Care Act guidance. But interestingly, the Care Act guidance doesn't say that it's statutory guidance or what that means. And it may well be that the sector thinks that it's not quite the same. But if they were looking at the Care Act, they would know that there is the statutory underpinning that makes the guidance effectively the roadmap that they must follow. Section 78 says that local authorities must act under the general guidance of the Secretary of State in the exercise of functions given to it by this part of the Care Act or by regulations. And this section, Section 78, has been referred to in the 1970 Act as well, to make it crystal clear that the old structure still applies for control from the top, from the Department of Health and Social Care. A bit later on, in terms of legal history, a lawyer wrote this article in Community Care or Local Government Law or somewhere for social workers. In the beginning was Section 7, which said that local authorities shall, in the exercise of their functions, including the exercise of any discretion conferred by any relevant enactment, act under the general guidance of the Secretary of State. So this was a peculiar type of legal authority for social workers. It was guidance rather than law. On the one hand, we had to follow it. How can something be binding if it is guidance? The answer has stood the test of time. And this, ladies and gentlemen, is the leading case on the legal status of guidance. And look when it was decided, back in 1998. Parliament has required local authorities to follow the path charted by the Secretary of State's guidance, with liberty to deviate from it where the local authority judges on admissible grounds that there is good reason to do so, but without freedom to take a substantially different course. So it's still guidance, because exceptionally and with good reason, social workers can deviate slightly from it, but it carries its own legal authority because almost all the time we must follow it. And the writer went on to say that by doing this, Parliament delegated authority to the executive, that's government, to create guidance that social workers should follow, irrespective of the wisdom of that guidance. The writer said there are plenty of examples of guidance which have enlarged the law by embellishing the bare bones of the legislation and creating additional obligations on social workers. The codes of practice we have to follow under the Mental Health Act, Mental Capacity Act, and Deprivation of Liberty Safeguards guidance are all examples. So it can usefully enlarge on the detail of our obligations, but it cannot be used to diminish our obligation to give precedence to human rights. So for anybody who has been properly educated to do social work, they ought to know the status of the guidance and why some parts of it say must and some parts of it say should. The parts that say should are all about this kind of tone, stuff that governments, local authorities should follow unless there's a very good reason not to. But then why does the guidance sometimes say must? Well, when it came to the Care Act guidance, it was written for human beings, workers and ordinary people, and people who draw on services. And the musts were put in to save anybody going back to the actual boring legislation. In the guidance, whenever you see the word must, it means that there is a duty in the Care Act. And it's simply been transferred over to the guidance in authoritative terms so that nobody needs to go and look at the law or the regulations. And that makes sense, doesn't it? But where it says should or should not, that is the essence of statutory guidance. The nub of all of this information is that guidance is brilliant for central government. It leaves maximum scope for innovation and flexibility locally, and it enables the government to distance itself for any poor outcomes like Birmingham or Croydon or Thurrock or Slough going into Section 114 bankruptcy. But it's also sufficiently clear in terms of how council should be acting to enable ministers to monitor and review progress towards their national policy objectives. So if I ask this question, why does the status of guidance matter so very much for people working in the health and social work sector? 3 reasons come to mind. Firstly, all of the guidance, because it's not quite law, needs to have been written in the first place, absolutely squeakily cleanly and consistently with the legislation it is enlarging upon, and consistently with existing case law and public law principles. That's why when the Care Act guidance was written, it had to be vetted privately by people who knew what they were talking about, even if it had been co-produced by ordinary people and local authority staff in the first place. And it's why all of the musts in the guidance can be traced back to duties. The shoulds can be traced back to powers or discretions in the Act and regulations, and those are the places where councils have to show flexibility. The should nots achieve the status of being virtual prohibitions against local authorities for doing certain things, and those can lead to judicial review if councils ignore them. The second reason the status is important is that the guidance will be used by judges, if there is ever another case on the Care Act, to read in words that they think are needed to make sense of the law itself, or to have a checkup of what Parliament's purpose was if there's a query about that in an ambiguous situation. And I say that because, believe it or not, well before care plans were a part of the governing law that we all live under, they still had to be written and issued by social work staff. And that was because the judges in around 2010 saw them as being absolutely central to accountability for the decision as to how much of anything was defensible, conceivably enough to meet needs. And the same thing has happened with the duty to give reasons. It isn't in the Care Act in certain places, but it has been implied into the law, even where the law itself doesn't require reasons, based purely on public law principles and the guidance. And the third reason that guidance status matters is that sometimes it goes too far. Sometimes it is misused by an overpowerful or desperate government. And that means that if you do work in the public sector, you need to know when that might be the case, because of all of the reasons for not following the guidance. The fact that the guidance is itself unlawful is the very, very best reason for professionals being brave enough to say, nope, not this time. The next slide covers the concerns of the statutory joint committee in Parliament on statutory instruments after COVID. And it's a page full of criticisms of COVID guidance being misused because it imposed more severe restrictions than the law had, and because it prohibited people from leaving their homes without reasonable excuse and gave some, but not all of the excuses that would be considered reasonable. None of the restrictions mentioned in the third bullet were included in the regulations. They were provided to be a helpful flavour of when the police would probably take action, but they were not legally enforceable. So this is a really solid example that the Department of Health can be responsible for guidance that is not lawful. And so I wanted to make good, by way of referring to the case law, my claim that care plans were born of the guidance rather than law. And there's a reason I'm going to do this, which is because I'm aware that the NHS and the mental health trust system sometimes overlooks a duty to do care planning on the footing that it's just the budget that matters and that there is no legal duty to provide a care plan. I'm hoping to bury that position in terms of anybody who can be bothered to learn public law. And I'm going to go back to 2010 in a case called Sava. It was a case that got to the Court of Appeal under the old legislative framework, for those of you who remember the 1990 Act and the Chronically Sick and Disabled Persons Act. And everybody accepted that in those bits of legislation, there was no duty, no explicit duty to give reasons for how a council calculates the person's final budget. The judge pointed out that the whole policy for the Care Act, for the system, was founded on the principles of that guidance that I mentioned, putting people first. The judge said that the document and the guidance issued by ADAS, that's not even the government, that is the advice issued about the policy by ADAS, the Directors of Adult Social Services. All of it demonstrated a clear policy to provide service users with transparent information about how personal budgets were arrived at. And the judge referred back to that case that I've mentioned as legal authority for holding that there is a common law, public law duty on local authorities to provide, wait for it, it will give you great joy, evidence-based reasons as to how and why a council believes it's arrived at the appropriate figure to meet needs, so that it can demonstrate, if challenged, that it is discharging its statutory duties. And the judge said this: if a local authority were entitled to just notify a bald figure without any explanation, the recipient would have no means of satisfying him or herself that it was properly calculated. The guidance requires it to be possible for people and families to challenge these decisions. An absence of explanations would make it impossible to mount such a challenge, whether by way of complaint or by way of litigation. And the implication there is that that's not a jolly good idea. That is, in fact, anathema to public law. So the judge said it must be incumbent on those responsible for this provision to be transparent and to explain individual decisions in a precise and clear manner. And I love this bit, and you will too. The council submitted that if Mrs. Sava wanted an explanation of how her budget had been calculated, she could have had every opportunity to receive one after getting the decision letter. She could have just been told by the social worker or support broker. The judge said, I do not accept that that would be sufficient. It is for the panel to provide or approve the reasons in a document. Any other means of communication would lack the necessary authority and consistency. So since 2010, ladies and gentlemen, it has been the law that the final decision maker on a final plan and budget is the body of people or the individual who must provide intelligible, rational, evidence-based reasons. So if the frontline social worker suggests that £30 will be enough for something and the panel thinks it should be 15, the panel needs to sensibly explain why the frontline social workers' reasoning and recommendations do not meet with their agreement. Once you know that that is the law, you can't practice in the same way. And if you're a member of the public, you can't just sit back and take whatever you are given. Surely you must fight back. So this is where I turn my attentions to the NHS. The CHC National Framework is a piece of government guidance that comes from the Secretary of State. It's all about continuing NHS healthcare, and it includes policy guidance and practice guidance. It did not, when it was last updated, seek to change the eligibility criteria for who gets continuing healthcare. It says that all of those involved in it should become familiar with the whole national framework. So that's an exhortation to the NHS that it matters. And then it explains what the framework is underpinned by. In other words, those references to musts and shoulds, just like with social care, will relate back to the parallel obligations or discretions derived from the NHS legislative framework. It reminds people that ICBs, NHS England and councils have got legal duties and responsibilities in relation to NHS CHC and that they must comply with their responsibilities. We did a search today and we found 97 instances of the word must in this framework and 832 exhortations expressed with a should or a should not. And I'm beginning to think that you're following my meaning, that the legal history for what's happened and what the meaning of Care Act guidance is also good legal history for what would happen if anybody challenged an ICB for ignoring public law principles in terms of care planning for a person who is eligible by dint of having a primary health need. So I'd like to make that good, and I would like to give you a scenario involving a CHC patient. Imagine the NHS manager says to the patient's family about an argument about the funding for the care plan, well, we use a resource allocation system. And it doesn't say anywhere in the national framework that we've got to be transparent as to its base figures or assumptions, does it? And it doesn't say that the budget has to actually be sufficient, does it? It doesn't say must in connection with this at all. I'd like you to think about what I think a judicial review court should be prepared to say to any ICB that says such a thing. For a start, the NHS framework does require sufficiency. Page 93 says this: the funding provided by ICBs in NHS continuing healthcare packages should be sufficient to meet the needs identified in the care plan, based on the ICB's knowledge of the costs of services for the relevant needs in the locality where they are to be provided. Now, I grant you it does not say must. So I'm going to put myself in the position of an NHS manager who has to interpret what amount, if any, wriggle room this guidance provides them with when it comes to funding a CHC care plan. Suppose they try to say that they read those words to mean that whatever is offered will simply have to do, and will simply have to be regarded as being enough. In other words, the words should be sufficient suggest that that's what always happens and people should take what they're given. Well, if that's what an NHS manager thinks, it would have to be on the basis that they'd never heard of public law challenges to care plans and know nothing of public law principles requiring a rational, evidence-based approach to care planning, in my view. And I would remind you that in a social care case in 2012, the Supreme Court said these magic words: crucial to any resource allocation system being good for anything is a realistic nexus, both between the needs and the points, and between the points and the pounds or the costs. And finally, going back to Sava, the court referred back to an earlier case called AESI, and it was said there that failing to give reasons is tantamount to making shots in the dark in circumstances where the light could so easily be switched on. In this case, in Sava, the judges said that the client, without being able to properly understand the use made of the resource allocation system, she and anyone acting on her behalf is left totally in the dark as to whether the monetary value is adequate to meet the assessed need of the score. So, in adult social care, a judicial review could be won every day of the week using these principles. Very few people seem to bother to do judicial reviews of ICBs because they know that the complaint or the challenge to an eligibility finding has to go to an independent review panel and ultimately to the Ombudsman. And because they don't know anything about judicial review, they don't bother to stand up to ICBs and bring them to the administrative court. The remaining slides in this very short presentation are other juicy examples of codes of practice that have this status. So I've got the Homelessness Code of Guidance there with reasons from paragraph 917, why acts or omissions by people who are mentally ill should not mean that they are considered to be intentionally homeless. So if you're a social worker, knowing the status of the Homelessness Code of Guidance gives you tools to use in polite discussions with your housing authority colleagues. Another example is the Mental Capacity Act Code of Practice. As you can see there, it explains what it is done under, Section 42, and it explains that there are some people who are obliged to follow it, and then there are some people who are not obliged, but who would be prudent to be following it. Ordinary men and women, in other words, who are also making best interest decisions for their loved ones. But towards the bottom of this slide, it makes it clear that the duty to have regard to the code covers donees of a lasting power of attorney, a deputy appointed by the court, any independent mental capacity advocate, and anybody who is a representative appointed under the dole's provisions. So it isn't possible to just say nobody need read the Mental Capacity Act code any longer. I hope that that is interesting to you. The Mental Health Act Code of Practice is my concern at the moment because I'm doing some work for the NHS. Unsurprisingly, I have set out here that it has statutory underpinning and that it is delivered under Section 118. It says in Section 118 who it is for and what the duty is to have regard to it. And then I just refer you to another lawyer's views about the code. He says, in my experience, most professionals have not read any of the codes. And if they had, I suspect we would not have the problems that now exist. So there are some excerpts from the code here, which I have highlighted. I'm not going to expect you to focus on them now, but I want to finish with the most important case on Section 117 of the Mental Health Act, because it is a case from 2021 involving Section 117 discharge from mental hospital, in which a judge tore through the approach that he had to deal with to the way a local authority and a CCG had discharged a person from hospital. The judge said that this document does not adequately identify and thereby demonstrate by assessment the needs of this young person, how to meet them, and who is to do that. It's a pretty feeble document. The judge said that the code of practice had not been followed and applied with sufficient rigor. The document was signed on the date of discharge and cannot therefore have been discussed and considered in good time. The mother did not sign it, indicating she was not consulted or given a copy. No witness statement says that anybody referred to the code of practice using it as guidance. And the plan does not set out in clear terms what was needed, what was to be done about the issues raised, by whom and by when. Simplistic analysis and identification of the needs without the necessary, precise, focused and detailed manner in which those needs are to be met. Broad aspirations without setting out in detail the practicalities for her day-to-day care and support. Well, it's no good. It's not thorough and it is lacking in focus and detail. It is non-specific. And finally, if you would just look at the large words there, the judge said it's a plan for assessment and more planning. And you can hear his disdain coming through the judgment. The document does not do as I described. It does not provide a vital and important bridging link, enabling any new care provider to gain a clear insight into the key aspects the plan of going forward is going to have to cover. It is an unsuitable and defective tool for the job required. The guidance set out in the code has not been followed. The care plan doesn't do what the code says it must, and no reason has been given for any departure from the code. So this document is unlawful, and the claimant is entitled to a mandatory order requiring that a new assessment be conducted. Isn't that great? Can you see why I am frustrated as an adult social care lawyer, and I think that the rule of law has simply been buried? When I have had occasion to say in this PowerPoint rhetorically, how often does this happen in the real world? How often do people discuss these obligations at professional huddles. So that's the end of the material, and people might like to take a screenshot of this, which is another way into staying in contact with us. I'm going to look at the chat box to see if there are some questions here, and I will then sort that out. Can a panel delay a decision? In my local authority, they have a panel once a month, which is delaying getting support in place. I think that the Ombudsman would say that a panel once a month is not enough. But I would suggest that going to the Ombudsman is probably one way of solving it. Equally, going to the monitoring officer and saying that you think that having a panel once a month is, in fact, a breach of the Care Act and a breach of public law. The monitoring officer would have some responsibilities there. Kath has asked, thinking about local authority panels, can members remain anonymous? Or is there something I can use to find out how many people were on the panel and who they were, and perhaps how competent they were? Yes, you absolutely can, Kath, because the decision maker, whether it's a group of people or whether it's one person, they have to be competent to make the decision. They could not be the tea boy or the post girl. They would not count as competent to make the social care decisions in terms of the values of social work, etc. Danielle has asked, what about a borough that has no autism crisis services and is keeping people in A and E at risk of section? Is this unlawful? That's not a question about the guidance, unfortunately, so I'm not going to answer that today. Judith says we don't have a panel, but we have a complex needs forum. How can this show reasonable adjustments for learning disability? Well, Judith, it doesn't need to show reasonable adjustments because learning disabled people will not be at the panel. In terms of procedural fairness, there is case law involving Wandsworth that says you can make written representations, and in exceptional cases, you can be there to rock up and make representations yourself if you have a manifest contribution to make. But there is no chance of succeeding in a judicial review that says people with learning disabilities or people who are affected by the decisions made would need or would have a legal right to be at the panel. The idea that the person is given the panel's reasons is like a compensatory factor for that inability of the system to allow for people to actually be there. The judges do not want to see panel hearings or decisions or huddles over judicialized. Stephen asks, should panels be recorded and discussions be available for challenge? Well, a local authority that is using Zoom, for instance, or Teams to have a multidisciplinary panel from people using remote offices or working from home, it's hard to say that it's hard to say whether they do record them or not. I think that it would be sensible for them to record them, but I think it's hugely unlikely that an ombudsman would stick their neck out and say that not doing so amounted to fault. And there is certainly no judicial review authority or case law on it at the moment. And Lynn says, should you need a Care Act advocate involved in a review of a care plan? That's not really a question about the guidance, but I can think of a way of making it so. The guidance says that you will be entitled, if you otherwise trigger advocacy, to have an advocate at a care plan review. If in fact you look up the law, section 67, which is the route into the process in question being one which advocacy is attached to, says that advocacy attaches to revisions, not to reviews. But in fact, I am sure that the government guidance referring to advocacy at reviews is because the government was told by local authorities that reviews and revisions are usually held at one and the same time. And therefore, since there may need to be an advocate for the revision, there also should be an advocate for the review. Gribben asks, can you please tell me when I will receive the PowerPoints and the training material? If you have signed up to our roundup, they should have been delivered already. And if they have not, all I can do is apologize and tell my operations manager that that has not been done. I have to say we are short-staffed at the moment as ever, and I certainly have no desire to take your money without giving you good value. All right. So thank you very much, everybody. And I look forward to seeing you next week. We're going to look at assessment next week. Thank you. Bye-bye.